Welcome to another episode of California Landlord Help. Today's 10-minute legal summary will be on the topic of implied warranty of habitability. Here's a 1-minute summary up front, just in case you hate overly long YouTube videos and introductions as much as I do. The implied warranty of habitability protects you as a tenant from having to remain and/or pay the full amount of rent that is normally due in instances where the premises maintained by the landlord are in violation of building and housing code standards which materially affect health and safety. Unless you are at fault for creating the violation, you might be entitled to remedies such as a reduction in rent, a termination of your lease without penalty, or the right to have the problem repaired and deduct the expense from your next month's rent. And, depending on the landlord's handling of the matter, you could be entitled to additional damages for your legitimate emotional suffering. There are nuances and exceptions to the implied warranty of habitability that are not discussed here, nor in this entire presentation, but you will at least have a working knowledge of the principle by watching the rest of this presentation. What is it? Under California law, a property for rent must be habitable and in good repair. California courts have mandated that an implied warranty of habitability exists in all residential leases. This obligation has been affirmed by cases such as Hinson v. Dulles, Green v. Superior Court, Stoiber v. Honeychuck, and codified into California law through statutes such as the California Civil Code, Section 1941, and the Health and Safety Code, Section 17920.3. When does it apply? The implied warranty of habitability is an obligation that the landlord must abide by at the beginning and throughout a residential lease. So what does this technically require a landlord to do to ensure the implied warranty of habitability is not breached? And what are the landlord's consequences if the landlord breaches? This presentation will answer that. Throughout this presentation, the implied warranty of habitability may be abbreviated as IWH. Bare living requirements. The first cases to recognize an implied warranty of habitability for all residential leases in California, such as Stoiber v. Honeychuck in 1972 and Green v. Superior Court in 1974, did not hold that a leased premises must be kept in perfect, visually pleasing condition, but rather that bare living requirements be maintained. What are bare living requirements? Since it would have been short-sighted for the court to enumerate an exclusive list, the court in Green instead held that substantial compliance with those applicable building and housing code standards which materially affect health and safety will suffice to meet the landlord's obligations under the common law implied warranty of habitability we now recognize. Statutory requirements. Under the California Supreme Court's decision in Green, there are certain defects that may cause a building to be considered substandard to the extent these defects endanger the life, limb, health, property, safety, or welfare of the public or occupants. Green held that the implied warranty of habitability does not require that a landlord ensure that leased premises are in perfect, aesthetically pleasing condition, but it does mean that bare living requirements must be maintained. Such bare living requirements would probably be considered breached if they failed to substantially comply with the applicable building and housing code standards which materially affect the health and safety of occupants. The California legislature has extended the decision in Green and defined habitability requirements under Civil Code 1941.1 and substandard housing under Health and Safety Code 17920.3, which I will discuss. And I just noticed that number 3 is bleeding into the picture. Please forgive me. I could fix that, but I don't think it's that important right now compared to the substance. 4. So it's not only physical. The implied warranty of habitability, as I just mentioned, will bound an owner to additional features if they were promised in the property's advertising or rental agreement. However, the implied warranty of habitability is not concerned with matters that do not specifically relate to the health and safety of the occupants or public. One more thing on that. So though the implied warranty of habitability generally raises concern of physical defects, there is some case law that suggests that the implied warranty of habitability can be breached when the landlord has security measures in place or asserts that such measures are in place but actually are not or fail to be maintained. Let me know if you need the case on that, but that just goes to show that it's not just physical defects. It could also be defects in the security of the property. Requirements for habitability. So if a dwelling lacks any of the following, it will be deemed untenantable. In other words, uninhabitable. So just run through this real quick. Number 1, effective waterproofing and weather protection of roof and exterior walls, and paint that does not pose lead hazards. 2, plumbing or gas facilities in good working order. 3, a water system that delivers hot and cold water to the tenant and a functioning sewage disposal system. 4, heating facilities in good working order. 5, electrical lighting with wiring and electrical equipment in good working order. 6, all premises under control of landlord free of accumulated debris, filth, rubbish, garbage, rodents, and vermin. 7, adequate number of appropriate trash receptacles for garbage in good working order. 8, floors, stairways, and railings in good working order. 9, a locking mail receptacle for each resident if the resident lives in a residential hotel. And lastly, a nuisance provision, which covers a broad spectrum of problems that could be deadly, dangerous, or even just immoral, such as permitting criminal activity on the premises. So in other words, if you don't find your violation to fall under the specific categories enumerated in 1 through 9, there's a chance it could still fall under the broad sweeping category of nuisance. So additional governing statutes. And the picture you see here was of that Berkeley apartment where the contractor used improperly treated wood that essentially had dry rot and the balcony collapsed. So that would be an example of breach of habitability. Major one. In addition to Section 1941.1 and 1941.3 of the California Civil Code we just mentioned, the implied warranty of habitability is also governed by the California Health and Safety Code. And I'm going to stop mentioning the actual numbers. It just sounds more confusing than it is. So if you need the specific Health and Safety Code sections or the California Civil Code, just message me, send me a comment. I'm going to try to eliminate the numbers, though, from now on. So what I was saying was, in addition to the California Civil Code sections and the California Health and Safety Code sections, which speak to inadequate sanitation, a building could also be deemed substandard housing under a different section of the Health and Safety Code if the building or any portion of it contains inadequate sanitation or structural hazards. So, in other words, there's a couple ways you could deem a building uninhabitable. One of them is based on inadequate sanitation. Another one is structural hazards. So even though there's quite a bit of overlap between the Health and Safety Code and the Civil Code, here's a list of items covered in the Health and Safety Code. And again, there are some overlap. But number 1, lack of proper, let me just talk about I'm talking about the Health and Safety Code right now. So lack of proper toilet and bathtub or shower in the dwelling unit. 2, lack of proper kitchen sink. 3, lack of hot and cold running water to plumbing fixtures. 4, lack of adequate heating. 5, lack of or improper operation of required ventilating equipment. 6, failure to provide minimum amounts of natural light and ventilation provided by the Health and Safety Code. 7, lack of electrical lighting. 8, dampness of habitable rooms. 9, infestation of insects, vermin, rodents as determined by a health or code enforcement officer. 10, general dilapidation or improper maintenance. 11, lack of functional sewage system. 12, lack of adequate trash storage and removal as determined by a health or code enforcement officer. So again, those are the items covered by the Health and Safety Code. So between the California Health and Safety Code and the California Civil Code, you have plenty of ammunition as a tenant to raise an implied warranty of habitability claim if you think there's a violation. Next, the Uniform Housing Code also specifies minimum square footage requirements for bedrooms and other rooms. So if you have a room that you just feel can't possibly be legal because it's so ridiculously tiny, like a broom closet, you might have some rights under the Uniform Housing Code. And lastly, there are some local municipal codes that could provide further habitability requirements on a local basis to complement the broader ones mentioned above. So here are some real-world examples of implied warranty of habitability breaches to give you an idea of what the court is looking for. So starting with Green versus Superior Court, this was one of the early cases, after Hinson v. Dallas, but this was in 1974, and in Green versus Superior Court, a tenant had refused to pay rent. A tenant had refused to pay rent to the landlord because the landlord had refused to repair defects such as a collapsed bathroom ceiling, as well as address the rats, mice, cockroaches, lack of heat in several rooms, plumbing blockages, exposed and faulty wiring, and stove that was installed illegally. So prior to Green and Hinson v. Dallas 2 years earlier, in 1972, The common law doctrine had held that a landlord was under no duty to maintain leased dwellings in habitable condition during the tenancy. So cases like this one and Hinson v. Dallas a little bit earlier did away with that outdated agrarian notion, which had held that a tenant's duty to pay was independent from a landlord's duty to maintain the premises. I'll elaborate that next. So in 1980, there was a case called Stoiber versus Honeychuck, and the tenant had complained about leaking sewage, defective wiring, structural weaknesses in the walls, deteriorating flooring, falling ceiling, leaking roof, dilapidated floors, broken windows, and several other unsafe conditions, with minimal to no action being taken by their property managers. Furthermore, the Kern County Health Department had sent a notice that the premises needed to be vacated and demolished after the health department found essentially the same defects as the tenant. The tenant sued for special, general, and punitive damages arising from the discomfort, property damage, and extreme distress the tenant claimed was due to the property manager's knowing and willful disregard of her complaints. The court in Stoiber, again this is Stoiber versus Honeychuck, established a new precedent in which a landlord's breach of habitability can be considered a tort, similar to a personal injury, in which potentially special, general, and even punitive damages could be awarded based on the landlord's conduct. And lastly, Knight versus Hallstamer in 1981. So this case dealt with a tenant complaining about wall cracks, water leaks, heating and electrical fixture problems, broken and inoperable windows, rodents, cockroaches, and the lack of sufficient heat. The court in Knight allowed the tenants to raise these habitability violations as a defense to the landlord's unlawful detainer against them, and it made no difference that these conditions existed at the time the tenants moved in. So another subsection of the California Civil Code mandates that the landlord shall install and maintain locks on exterior doors and windows. So for doors, an operable deadbolt lock shall be installed on each main swinging entry door of a dwelling unit, as well as on horizontal sliding doors. For windows, there must be operable windows, and it requires window security or locking devices unless the windows are at least 12 feet vertically or 6 feet horizontally from the ground, roof, or any other platform. 3, common areas. There must be a locking mechanism on any exterior doors that provide entry or exit to or from common areas with access to dwelling units in multifamily developments. And there is a duty to notify, and the landlord has a duty to repair. So the tenant is responsible for notifying the landlord or landlord's agent of any inoperable locks, and the landlord would have a duty to repair any issues that are properly notified to the landlord. And 5, off-premises liability. So maybe you're thinking that in this following example must be an only in California type of verdict, but there was a case called Donchin versus Guerrero, and in Donchin, this is a 1995 case, and in Donchin, the court found that a landlord could be held liable for a dog attack that occurred off the premises if it could be shown that defects in the landlord's property failed to keep the dog secured. So do you understand what this means? The dog attacked somebody. It was a tenant's dog. It attacked somebody like blocks away, totally outside of the property, totally outside, the confines of the landlord's property. But the court found that a landlord could still be liable if it could be shown that there were defects in the landlord's perimeter, and that allowed the dog to escape and attack somebody even blocks away off the premises. So in regard to locks, as well as the entire residential premises owned by the landlord or agent is not liable for any violation unless he is made aware of the violation or has actual notice and fails to correct the violation. Failure by the landlord to take corrective action on matters substantially affecting health and safety could be grounds for determination of breach of the implied warranty of habitability. Smoke alarms. It's worth noting that a different section of the California Health and Safety Code contains a requirement that each dwelling unit contains a smoke alarm or fire sprinkler system. And if the landlord performed any new construction or performed additions, modifications, or repairs over $1,000 in a single room, a smoke alarm must be added. So that was a requirement. Next, maintenance from testing. At the time of move-in, the landlord is obligated to ensure the smoke alarm is operable. After the tenant moves in, the tenant is obligated to notify the landlord of any inoperable alarm within her unit. The landlord or agent must repair any reported deficiencies and may enter the unit with reasonable notice of the tenant, generally it's 24 hours, to repair, install, test, and maintain the smoke alarm in the tenant's unit. However, the landlord would not be in violation of the California Health and Safety Code for any deficiency in an alarm system in which the tenant did not report the defect in her unit. So while we've touched on the topic of maintenance and testing, it's worth noting that cases such as Peterson versus Superior Court have held that the implied warranty of habitability obligates the landlord to perform inspections of the premises to discover dangerous conditions during the tenancy. However, correction of defects are only required where the defects are actually discovered or should have been discovered through a reasonable inspection. The landlord will not be liable for defects for which the landlord was not aware or for defects that could not have been discovered through reasonable inspection by the landlord. And lastly, punishment for violation. A violation of the fire alarm provisions of the California Health and Safety Code can be punished by a fine of up to $200 per offense. So a sampling of, I'm talking about inadequate sanitations. So, these are structural hazards under the Health and Safety Code. So a sampling of the type of defects that may count as structural hazards under the California Health and Safety Code include deteriorated or inadequate foundations, defective or deteriorated flooring or floor supports, members of walls or vertical supports that split, lean, list, buckle due to defective material or deterioration, members of ceilings, roofs, roof supports, or other horizontal members that sag, split, or buckle due to defective material or deterioration, or are of insufficient size to carry loads with safety. Fireplaces or chimneys which list, bulge, settle, or are of insufficient size and strength to carry imposed loads with safety. Faulty weather protection, such as deteriorated plaster, ineffective waterproofing of exterior walls, or weathering due to lack of paint or other protective covering. Any building, portion, device, apparatus, equipment, combustible waste, or vegetation that the chief of the fire department or deputy deems to be in such a condition as to cause a fire hazard or explosion, or provide a ready fuel to worsen the intensity of a fire or explosion arising from any cause. Any building or portion determined to be an unsafe building in accordance with the latest edition of the Uniform Building Code. Any portions of the building not provided adequate exit facilities unless they conformed with all building codes at the time of their construction. Any buildings or portions occupied for unintended purposes such as living, sleeping, cooking, or dining. Some tenant protections. So notice is not required. In other words, although providing notice to the landlord about a dilapidation in the premises affecting the implied warranty of habitability is recommended and provides further legitimacy to the tenant for withholding rent, cases such as Knight versus Hallstamer have held that a tenant is not obligated to provide notice before exercising tenant remedies for habitability breaches. Nevertheless, it would be a good idea for the tenant to first give notice, either oral or written, to the landlord to perform the necessary repairs. If the condition is not repaired within a reasonable time after the tenant's notice to the landlord, generally 30 days, then the tenant may proceed with one of the following remedies, but he can do it without notification as well. It just bolsters the tenant's case to provide notification. So the landlord is barred from retaliation, and I'll talk about the remedies in a sec, but I just want to say the landlord is barred from retaliation against a tenant for exercising the statutory right to pay and deduct the expenses of repairing the dilapidated conditions that the landlord is obligated to repair. So the landlord is barred from instituting unlawful detainment proceedings against a tenant simply because the tenant is exercising their lawful remedies. And where warranted, a tenant could recover general, special, punitive, and emotional damages for negligent or intentional conduct by the landlord or landlord's agent, as well as attorney's fees. The landlord could also bring, the tenant could also bring a breach of contract action against the landlord for failing to maintain the minimum standards of habitability required for dwelling units in California. And lastly, if a landlord brings an unlawful detainer suit against the tenant for non-payment of rent, the tenant can raise the landlord's violation as the tenant's affirmative defense for non-payment of rent. So the tenant does have some obligations. And you see the picture here, that would be a tenant committing just waste. But a tenant must keep their rented unit as clean and sanitary as the premises permit, dispose of all rubbish and garbage in a clean and sanitary manner, and properly use and operate all electrical, gas, and plumbing fixtures. And lastly, not willfully or wantonly destroy, deface, damage, repair, or remove any of the structure or dwelling unit or the facilities or equipment. So what I'm talking about here is the California Civil Code says that a tenant cannot engage in negligence or outright malice to create the defective conditions and therefore withhold rent. It's summarized in this axiom: a tenant should not be permitted to benefit from his or her own wrong. So what if the premises were fully habitable before the tenant moved in, but the tenant's negligence or malice created the defective conditions? Should the landlord be held responsible for the defects that were the fault of the tenant and not the fault of the landlord? The answer is generally no. Just as the law implies the duty of the landlord to maintain the premises in habitable condition and imposes an obligation on the tenant not to create inhabitability or exacerbate defects by breaking windows, failing to remove one's own trash, etc. Under the precedent that a tenant should not be permitted to benefit from his or her own wrong, a tenant would not be able to avail himself of the remedies normally available to aggrieved tenants, such as repair and deduct, for a plumbing problem that the tenant intentionally caused, so as to use the defect as an excuse from paying the full rent due. So the implied warranty of habitability, it's not waivable. Some landlords may attempt to entice a tenant to ignore or waive defects in the habitability of a dwelling through incentives such as discounted rent. But it doesn't matter what the incentive or habitability breach is. Cases like Knight versus Hallstamer and Smith versus David have held that a tenant cannot waive a condition that breaches the implied warranty of habitability, even if the tenant's waiver is intentional and voluntary. And prior knowledge is not relevant. Cases such as Knight versus Hallstamer have held that it does not matter whether the tenant knows of the dilapidated condition at the time of move-in. In other words, even a tenant who has full knowledge of the uninhabitable conditions at the time of move-in does not waive the implied warranty of habitability, nor waive the tenant's remedies against the landlord for the uninhabitable conditions. So, the 1980 California Court of Appeals case referenced earlier, Stoiber versus Honeychuck, which created the tenant's right to bring a tort suit against the landlord for breach of implied warranty of habitability, also created a three-part test in which a tenant wishing to prove a claim for a breach of warranty of habitability must first show the following. 1. An uninhabitable condition. 2. Actual knowledge or constructive knowledge by the landlord of the condition. And 3. Damages to the tenant. After a tenant has shown breach using a three-part test from Stoiber, which I'll explain shortly, the remedies a tenant has against his landlord include and exceed the remedies described in Civil Code Section 1941-1942. So Stoiber held that one of the remedies available to a tenant going forward would be to recover damages, the difference between the amount the tenant paid minus the actual market value of the premises as they were during the unsafe or unsanitary period of occupation. Another method for recourse by tenants is to collect the return of the rent already paid, as well as attorney's fees spent by the tenant in defending the unlawful detainer proceeding. Or the tenant could just abandon the premises if the tenant wishes to break the lease early without the ordinary financial penalties. And there's also one more. So the tenant can repair and deduct using up to 1 month's rent to make the repairs and deduct the amount spent on the repairs from the next rent due. This remedy is available to a tenant up to twice per year, and it's a remedy that's listed under the California Civil Code, and it permits the tenant to employ the repair and deduct procedure after the landlord fails to respond in a reasonable time to the tenant's notice. Even where a tenant has not suffered physical damages, a tenant could sue for emotional distress under the theory of negligent infliction of emotional distress by suffering emotional suffering due to the landlord's negligence, such as failing to make repairs, which the tenant can show induced serious emotional distress in the tenant. In order to make a claim for NIED, negligent infliction of emotional distress, California civil jury instructions look at a three-part test that you see here. Was the defendant negligent? Did the plaintiff suffer serious emotional distress? And 3, was the defendant's negligence a substantial factor in causing plaintiff serious emotional distress? So those were the 3 parts of the test that California civil jury instructions look at in order for a negligent infliction of emotional distress claim to proceed. Damages for IIED. So this is different from NIED. This is intentional infliction of emotional distress, IIED. And this is where there is extreme and outrageous conduct by the landlord. So the tenant could bring a suit for IIED And cases such as Stoiber have granted tenants claims for IAD where the higher four-part test was satisfied. This four-part test consists of the following elements: outrageous conduct by the landlord, intention to cause or reckless disregard of the possibility of causing emotional distress, severe emotional suffering, and actual and proximate causation of emotional distress by the landlord, or sometimes landlord's agent or property manager. So that wraps it up. I try to keep this, as short as possible, but there's a lot to cover. I hope this helps your understanding of the concept of the implied warranty of habitability. Questions, feedback, please let me know in the comments. I'm trying to make these better and better and get better every time I do these. I know I still make mistakes. I always will, but my goal will be to make fewer mistakes every time. Here's the usual disclaimer. I don't think I need to read it to you, but you can't become a surgeon by watching a YouTube video. You're not going to become a lawyer by watching this presentation. I know it usually goes without saying, and you probably hate to hear it because it sounds like a cop-out, but you do need to hire a lawyer for your specific situation. This is broad advice. It's not limited to your case. And I am an attorney, but I'm not your attorney until I have a valid written representation with you signed by myself and has not been terminated by either you or me. So it is important to make sure you have a lawyer who is cognizant of all the changes in case law and statutory law, because that could change every month. But this has been a presentation on the implied warranty of habitability, and I wanted to personally thank you for watching. I would love if you leave a comment and a like. I would really appreciate that, but obviously it's up to you. Thank you.